The next matter to come before the court this morning is Brandywine Preserve Cluster Association versus Kevin Carter et al. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you are the appellant and wish to reserve any time for rebuttal, if you let me know when you get started, I'm keeping the clock this morning, can keep you apprised with the passage of time. We have read the briefs and we're ready to see when you are.
Good morning. May it please the court, my name is Joe Oliver. I'm representing the appellant Jack Marcella. I would like to reserve 2 minutes for rebuttal. This case involves a foreclosure action. It was initiated by a condominium association to recover $3,935 in unpaid condominium dues. The case resulted in a judgment in favor of the condo association, and an order of sale was issued on May 7th, 2010. That order of sale resulted in an appraisal being conducted by 3 disinterested freeholders. That came in at $252,000 as the value of the real estate, and the appraisal was dated August 18th, 2010. The order of sale, though, was withdrawn without execution by order of court on November 23rd, 2010. 3.5 years later, on April 9th, 2014, a new order of sale was issued directing that the property be sold, and it was in fact sold without appraisal on September 5th, 2014. The advertisement for the sale made it clear that the property was going to be sold subject to subordinate lien. The advertisement indicated the amount of the appraised value of the property, and it indicated the amount of the unpaid amount of the lien, and then expressed the difference between those two numbers as a positive number. When in fact, the difference between those two numbers was a negative number. The value of the property was appraised at $252,000. The lien was $309,000. And the difference between those two numbers, and you have to remember, the only reason you're doing this calculation is because the lien is going to be on their property. It's going to diminish the value of that which bidders are bidding to buy. And so you take the value of the real estate, common sense tells you you deduct the value of the lien, and that you get a negative number. The ad should have said that this property has a negative equity of $57,987, I think the number was. And instead it said, we've got a value of $57,997 or $987, positive number.
Actually, the ad doesn't say we have a value, it says the difference between the two amounts is.
That's right. And it expresses that as a positive amount. And it says that the value of the property is $252. And the difference between that value and this number is, I think that it's fair to read that as to say that that's a value of $57,987. And that says that the minimum bid is 2/3 of that amount. So,
Okay, I'm sorry, go ahead.
in my view, I think that that's a mistake for that to express that. I think it's a mistake and it leads the bidders to believe that there's actually a value to be purchased at this auction.
Well, there is the value of the home, the property to be purchased.
But there is
a value, a fundamental value there of the property.
There is. There's not. There's not. There's 252. If the appraisal is to be believed, then it really is meaningless in terms of the actual value at the time of this property, because it predates the sale by 4 years. And we all.
Is your implication that the value, the appraisal in 2010 would have been more or less than the appraisal 3 years later?
I have no idea. All I know is that the value of real estate can change over 4 years, will change over 4 years. And from the Great Recession, we all know that the value of real estate can change in a month. I mean, significantly. I have no idea whether the value of this real estate is higher or less. All I know is that according to that appraisal, it was worth $252,000, but it was settled with a $309,000 lien, which meant that really there was no value to be purchased there because that lien was not going away.
So would you suggest that the sheriff should not have had a sale?
I would suggest that the plaintiff should not have asked for a sale, yes. I think that, in fact, that plaintiff should never have expected to get a bid. If this advertisement had not misled the bidding public, then there should never have been an expectation that there would have been any bid whatsoever on this property.
Well, let's assume these are not the facts that we have, but let us assume that plaintiff requests a sale. You have some, wealthy individual who's looking for a tax write-off. Understands that this property has a negative value, and this is precisely the type of investment that will help with his or her overall portfolio.
That presupposes that spending $1 to save 30 cents in tax makes sense, and it does not. It never makes any sense to spend $1 to save 30 cents. And what you're suggesting is that the tax write-off is that they're going to go out and spend it's $91,500 to save 30% of that. It doesn't make any sense. It doesn't happen. It doesn't work that way in the business world.
Wasn't the purpose of coming up with the $37,000 number to come up with the minimum bid? That's what the number's purpose was. It's not a minimum bid of 10%, which I think is normally, Dynakai, I think it's 20% on a foreclosure sale. In some of it's 10, right, $10,000? Wasn't the purpose of coming up with that calculation to give you a starting bid?
I'm not aware of any minimum bid in Summit County being $10,000.
It's always 2/3 of the appraised value.
2/3 of the appraised value.
Okay,
Yeah.
and this is 2/3 of the difference of what's,
Right, but it's not 2/3 of the appraised value, because the actual value is a negative number. At best, if it was going to be offered for sale, and quite frankly, I don't know why it was, because
nobody would have bought it.
Nobody would have bought it.
If anybody would have read this, no one would have bought it. And then the
if
next.
anybody would have understood it, you can read it, but it's misleading.
Well, is it misleading when you also consider that there's language that says that this is sold subject to?
Yes.
How?
You have to understand what that means. I understand what that means. We all understand what that means. We're trained to understand what that means. We went to law school. We've been doing this for years.
Well, to
Mr. Mercer.
that very point,
Yes.
the opposing brief says that your client has been doing this probably more than most of us as lawyers and should have understood it even better.
He's been buying properties.
That's it. That's
Right.
my point.
That does not mean that he understands what he's doing. I'm in private practice. I've got, clients with, multi-million-dollar companies that come into me with the dumbest mistakes. That I've had, just yesterday, I had somebody say to me, "Did you read the letter that the judge wrote?" And he's talking about a judgment entry, he calls it a letter. They don't get the concept. They don't understand the legalities, the significance of the term subject to.
Okay, but do they understand the meaning of the terms amount due? Because anytime you get a statement in the mail from a creditor, it's going to say amount due. This says amount due, MERS is $309,956.78.
It says that. Yeah.
It says amount due.
Yeah. It does. It says that. He made a mistake. I think that nobody can conclude anything other than he made a mistake. And a mistake, the defense, or rather the plaintiff in the case, is saying that caveat emptor should apply. The trial court said caveat emptor should apply. The trial court is saying if he'd have gone and researched the record, he would have found out that mortgage was there. He knew the mortgage was there.
Well, did he think he was going to get something for nothing?
He thought that the mortgage was going to be paid first on the proceeds of the sale, and then it would be taken off, as mortgages always are in foreclosure cases. He was unaware of the possibility that this mortgage would continue as a lien on the property. He didn't understand. He had a mistaken understanding, based in part just on ignorance, and based in part on an ad that expressed the value, that this property had some value, or suggested that this property had some value. I agree. I'm sorry.
If we go along with your position that you're asserting regarding this mistaken identity, or mistaken belief or understanding, how will any sale be protected or subject to finality from the next person who comes in and says, I didn't understand it. I didn't understand terms like subject to and amount due. Do you see what I'm saying? What is the legal precedent that you're asking us to set here?
Well, first of all, I don't think that I am asking you to set a legal precedent. There was another case that I cited in my brief where the bidder mistakenly believed that his bid was the high bid, and so he stopped bidding. And the trial court in that case, I can't off the top of my head tell you the name of the case, but the trial court in that case refused to set aside the sale and order a new sale. And on appeal, the court said that it was an abuse of discretion, because it was obvious that bidder in that circumstance would have bid more if he had realized that he hadn't yet made the high bid. And so they ordered a new sale. So I'm not asking this court to set a precedent. I think that a mistake is clearly a basis for setting aside a sale. This mistake is not just a mistake that originates with my client's ignorance of the understanding of the term subject to. It's also a mistake that flows from the advertisement, which I believe, I get. I can read the advertisement, I understand it. I know what it means. I can see that there's a negative equity there. I can see that the lien is going to stay on. Mr. Marcillo can't. And the fact he didn't, and the fact that the advertisement expressed the property as having a positive value, I understand what you're saying, Your Honor, but I can see how he would come away from that ad saying this has got a positive value. That is a mistake. And the statutes that suggests or tells the court how they're supposed to frame that says difference in value, but you need a common sense understanding, a common sense interpretation of that statute. The only reason that you're making that calculation is because that lien has been survived. The survival of that lien reduces the value of what you're offering to sell. Therefore, you must subtract the amount of the lien from the value of the property, and not the reverse. But they did the reverse here, so they didn't follow the statute. The common sense interpretation of the statutes requires that. And the common sense then, this ad should have said the property has a negative value of $58,000 and the minimum bid will be. It's not going to be a negative number, it should have been zero. I happen to know that.
Let me ask you a question. If say hypothetically the value of the property is $309,956.78. Say hypothetically that's the market value of that piece of property.
Okay.
The only lien on it that's being litigated here is the condo due lien. So really the value of it is $309,956.78 minus the $39,35 that's owed the condo.
If there's no other liens, yeah.
Right. So really, I mean, to say that you can't discount the fact that there is value here, and really all that was being sued upon was the $3,900.
I completely discount that there's value here. There is no value here. The property is not being sold free of all liens. Mr. Marcillo thought it was. He thought it was. He was wrong. He had a mistaken belief, inconsistent with reality, which is the definition of mistake that can be used to avoid the operation of caveat emptor. Some unintentional act, omission or error arising from ignorance, surprise, imposition, or misplaced confidence, a state of mind not in accord with reality. There's no question but that Mr. Marcillo's state of mind was not in accord with reality. It was based in part on ignorance, part of the definition, and also in part on an ad that didn't comply with the statute. I'm sorry.
Would you just remind me briefly of the way in which this matter was presented to the trial court? Was there a hearing below? I don't recall.
There was not a hearing below. There was a request for a hearing.
Okay.
We filed, Mr. Marcillo did not sit in his rights. In fact, he became aware of the issue because as he was driving away from the auction. He got a telephone call from the attorney for MERS, the holder of the mortgage that survived. And the guy said, you just bought that property subject to the mortgage. And he's going, well, yeah, but it comes off, when you give me the deed. And he said, no, it stays on.
And counsel, you're just now reaching to your 2 minutes of rebuttal time.
I'm done.
Well, you may reserve or continue as you wish, but your 2 minutes of rebuttal time is hanging in the balance.
Okay, I will. All right, thank you.
Good morning, Your Honors. May it please the court. My name is Erica Finley, and I am the attorney for Brandywine Preserve Cluster Association, a nonprofit community association in the state of Ohio, which is composed of 125 homeowners. speaking to the issue of appellant's allegations of the sheriff's sale advertisement not being in conformity with the statute or Revised Code 2329, I respectfully, while I disagree with the interpretation of appellant's interpretation of that statute, I think this is a matter of where the trial court looked at those issues and in fact exercised its discretion and found each alleged error not to be prejudicial to the sale purchaser. So I don't really think it's a matter of having to pick apart each of those alleged nonconformities in this matter when the trial court has already looked at each of them and they've exercised their discretion. And the case law, in my interpretation, even supports that the trial court has the discretion to uphold a sale even if it's non-conforming to the statute. Specifically, Ohio Savings Bank versus Ambrose, the Ohio Supreme Court found that while the statute itself uses mandatory language, there's still room for the trial court to exercise its discretion to grant or deny the confirmation of a sale. And therefore, the nonconformity or an alleged nonconformity on its face is not sufficient for this court to overturn the trial court's decision in upholding the sheriff's sale. Additionally, even we see the Ohio Supreme Court in Union Bank Company versus Brumbaugh, that the Supreme Court held that the trial court has to have abused that discretion in order to support a sale being set aside. So we're looking for an abuse of discretion, which is simply not here in this matter. And appellant has failed to demonstrate any abuse of discretion in itself. The only case in appellant's brief that he cites as an example of an abuse discretion is in Urick versus Urick Enterprises. This very court the trial court upheld a judicial sale. And the distinguishing factor for the court to overturn, for this honorable court to have overturned that particular sale was that there was never an appraisal at all in the underlying case. In this matter, in the case at bar, there was an appraisal of the property. Albeit it was 3 and a couple of months, years old, 3 years and some months old, we do have a distinguishing factor here. There was an appraisal. And looking at whether then there is a mistake, there's a hardship, or there's a fraud, we have to then turn to the doctrine, the well-established legal doctrine of caveat emptor. And all precedent supports the trial court's conclusion that fraud or mistake is not grounds to set aside a sale when the purchaser had prior notice of the argued defect at issue. So that is the linchpin. If there's prior notice, then that's going to negate any of the sale purchaser's arguments as to fraud, hardship, or mistake. We saw the Ohio Supreme Court in the case of Weir versus Snyder Sawmill Company, for example, held that a sale purchaser is not responsible for some lien that is not recorded or part of the title chain. So in that particular case, the doctrine of caveat emptor is not going to apply where the lien itself is simply not recorded. And the trial court in this matter addressed that issue, addressed the fact that there was proper notice that the sale was subject to. It was all over the place in the document. The answer filed by MERS notes that the sale, that the bank is requesting that any judicial sale be sold subject to, the property be sold subject to that mortgage. The judgment entry and decree of foreclosure prepared by plaintiff, whom I represented in the case, states in several places the property is to be sold subject to the bank, the MERS mortgage. It's in bold, it's underlined, it's made so that it's known to the purchaser. So notice was out there. It was in the advertisement, which is admitted by appellant's counsel, that the sale was subject to the mortgage. And that's the issue that the purchaser has with the sale. It's not whether he purchased it for something of value. It's that he does not want to assume this mortgage that he was properly notified of through the sale advertisement and through the court's file itself.
Well, the appellant, though, raises a valid point in saying it wouldn't have been too much to ask for the ad to express the value in a negative number. That would have clarified things rather than to suggest that it was a positive value.
Correct, Your Honor, and the issue is that, in my opinion, my interpretation, the sale advertisement is not intended to promote the value of the property. It's establishing what the set minimum bid is per Ohio statute.
But how can you do that in a vacuum? How can you establish what the minimum bid is in a vacuum of whether or not you have a positive value or a negative value?
The sale advertisement, Your Honor, it's to notify, the purpose of the sale is to notify any prospective buyers of what the property is going to be sold for. The purpose of putting the appraised value or noting the appraised value in the advertisement is to reflect how that minimum bid was calculated. So it's the sale purchaser's responsibility to determine whether the property has value in advance to showing up at that auction and bidding on the property. The purpose of the sale advertisement is not to notify them that here there's value in the property, but in fact just to give the facts of this is the sale, this is when it was held, this is how the sheriff calculated the bid, so that it's understood, but it's not meant to serve as this is how much this property you're buying is worth.
It is just what it was appraised at, not necessarily what it might be worth to someone that shows up at the sale, right? You can't
Correct.
presuppose what everybody's desire for this real estate is.
Correct, and the reason it's in there is that the Ohio Revised Code 2329 establishes how a minimum bid is calculated. And the code states that it's 2/3 of the appraised value. So that's a direction to the sheriff to set the minimum bid at that price. Certainly when we're dealing with a subject to sale, there's also an additional provision in the statute that says, but no less than 2/3 of the appraised value, no less than 2/3 of the difference between the amount of the mortgage and the value of the property. So that is a determining factor that the sheriff used in calculating this particular bid price. So the numbers are there to reflect how the sheriff configured that calculation, and it's the purchaser, any prospective purchaser's responsibility to in advance determine for him or herself whether there's value to be sought in that property. They should not be relying on the advertisement in and of itself.
Wouldn't you say that by the appellant's argument here, even the $309,000 mortgage should have been a negative number as well, since that's a debt that's due knowing on the property as well? The $309,000 is a negative number too.
Your Honor, the only purpose of putting the mortgage value in there, though, was just to show where that minimum bid price was reached from. And in fact, in this particular case, I don't think the court can ignore that there were additional bidders at the sale, which likens it to Harris Trust, where the 9th District upheld the trial court's confirmation where the property did not sell for a sacrificial amount, but instead sold for significantly more than both the minimum bid and the appraisal value. And that's exactly what happened here. The property didn't just sell for what the minimum bid was. There were multiple purchasers there who, appellant notes in his brief, bid up the price to the approximately $97,000 purchase price that it in fact sold for, which also negates whether if there were an appraisal and it appraised for a higher value, it wouldn't have mattered. The bidders were there, the public spoke, it was a public auction, and they reflected, as the general public, what they thought the price of this property would be, and they bid it up. So if the court were to go back and reappraise the value of the property, it wouldn't have made a difference in this particular case. The appellant also argues that he misunderstood that he was taking the property subject to the mortgage of nerves. And as I noted, he saw through the sale advertisement and the trial court determined that there were adequate notifications. Appellant also relies on a 6th District case Society National Bank versus Wolf, where the sheriff advertised the property for judicial sale and included the statement that there was access from that property to the state road. And that was a mistake. It was inaccurate information from the sheriff directly in the sale advertisement, necessitating the court to turn its eyes away from the doctrine of caveat emptor. We don't have something that amounts to that level here. There was not an inadvertent statement from the sheriff in the sale advertisement. And as appellant's counsel noted, the advertisement says the property is to be sold subject to, which is the very issue of this case, that appellant, the purchaser, does not wish to assume that mortgage.
Well, is the doctrine of caveat emptor dispositive in this, as the trial court finds that it is? Because this isn't a defect in title. What this is what a value might be placed upon this sale to any given buyer. So it's almost as if the state of affairs, we would presuppose that this would have a negative outcome for someone that purchased it, if we say that the fraud and mistake is precluded by the doctrine that the trial court used. But to get to that doctrine, we have to be all the way down the road presupposing that the purchase of this property for what it was purchased with is going to have a negative net effect on the purchaser, not knowing any other factors regarding this purchaser, the sale, anything else, or the mortgage that's being sold subject to. Perhaps that's not an enforceable lien that it's being sold subject to. I mean, we don't know any of that. So does this court make a finding that, in order to affirm it, does this court need to find that caveat that the trial court's use of that doctrine was appropriate?
Absolutely, Your Honor. The trial court relied heavily on the doctrine of caveat emptor in this particular case and reviewed all of the issues that appellant raised in this case as well, that well, I misunderstood, or I was tricked allegedly, or there was fraud. The trial court evaluated each of those factors and determined that no, there was no fraud. There was nothing, there was no mistake. There was nothing to be mistaken. The subject to is not a legal doctrine. It's subject to the mortgage. It's words from the English language that should be understood by any individual, and especially a sophisticated purchaser like appellant in this particular case. Along the same lines, the trial court also addressed any of the alleged nonconformities with Ohio Revised Code 2329 that were raised by appellant at the trial court level, and determined that in accordance with the Zeiss case, that there was nothing there that amounted to a prejudicial error that would have, again, negated the doctrine of caveat emptor. Additionally, appellant raised the issue of there not being a hearing at the trial court level. And I would like to respectfully request that the court, again, look at the precedents in this case, that Union Bank versus Brumbaugh, again, the Ohio Supreme Court specifically addressed that issue. In reviewing a judicial sale, the court determined that the discretion lies with the trial court. So just like reviewing any of the nonconformities with the statutes that were with the statute that was alleged, again, the trial court has a discretion in reviewing a judicial sale whether to set it for an oral hearing or not. And in this particular case, the trial court level, appellant filed at least two briefs and raised all of these issues, and the court addressed all of these issues. Therefore, the trial court properly exercised its discretion in determining not to hold a hearing in this matter. And furthermore, any additional review of the appraisal value, again, wouldn't have mattered because it was a public auction. And it's the public's responsibility to do their own homework and their investigation and not rely on a sale advertisement to establish the value of the property.
And counsel, I regretfully need to inform you you have reached the end of your 15
Thank you, Your Honor.
So thank you.
have to stress that no amount of research of the record has required a caveat would have corrected my client's ignorance of the law. Subject to is a legal term. It may not be complicated to me and you, but he did not understand it. And he was ignorant of its meaning and misunderstood its meaning. And he could research the record all day long. It wasn't going to correct that. There was no hearing in this case, as your Judge Moore indicated. There was a request for a hearing. And I think that it was an abuse of the trial court's discretion to not hold the hearing, while at the same time in his judgment entry saying the plaintiff, or rather the movement, didn't provide evidence that we require to establish fraud or mistake, and then to deny the same hearing at which that evidence would have been elicited.
Well, I thought about that when I read your brief, and I think I even made a note on it as to whether or not your client would have been precluded from preparing, for example, an affidavit to attach to the motion. In other words, a hearing, an evidentiary hearing, is not the only way to get that information before the court.
Well, that's true, it's not. But when you request an evidentiary hearing, and it's clear that that evidence needs to be elicited, and some of that evidence, a good deal of it, is in the possession of the plaintiff, and not in my client's possession, such that he couldn't put it in an affidavit, then I think the hearing should have been held.
Sure.
And also, this court, the trial court rather, characterized my client's ignorance as neglect. I don't know how you can, and it literally says the neglect is not the basis for avoiding caveat emptor. It's in the judgment entry. But how can you determine that my client was neglectful without having an evidentiary hearing to understand from his own mouth how he came to his understanding of what the situation was?
Well, how did the information get in the record about your client's other purchases or business, other real estate?
The plaintiff's counsel went and checked the real estate records and saw that there were some transfers. But that does not mean that he understands subject to. He's never experienced a situation where a subordinate lien survived. He didn't know that was a possibility in a foreclosure action. It was
And
his
counsel, I also need to inform you that your rebuttal time has expired, so.
Thank you.
Thank you both for your presentations this morning. Court will take the matter in advisement, issue a written decision, which will be known to both sides, as well as posted on the Ohio Supreme Court website.